Gibbons versus Ogden, 1824. New York law gave Aaron Ogden a monopoly. Only his firm could operate steamboats within New York waters. Another businessman, Thomas Gibbons, disregarded that law. He operated steamboats that traveled from New Jersey into New York. Ogden sued to halt Gibbons' steamboat business, citing the New York law, which gave him a monopoly. Gibbons countered that the New York law was unconstitutional because it interfered with a federal law that licensed him to operate his ships. The New York courts upheld the state law and enjoined Gibbons' operation. Gibbons appealed to the United States Supreme Court. If Congress had the power to license ships that traveled between one state and another, then the New York law would be unconstitutional or preempted. Here Congress asserted its power under the Commerce Clause and contended that a state cannot regulate interstate commerce that Congress chooses to regulate. Article 1, Section 8, Clause 3 gives Congress the power, quote, to regulate commerce with foreign nations and among the several states and with Indian tribes. Chief Justice Marshall's opinion provides the Supreme Court's first major interpretation of the words commerce and among. Ogden argued that the New York law granting him the monopoly was constitutional. Why? Congress lacked the power to regulate boats traveling between New York and New Jersey. Commerce, he contended, was limited to, quote, traffic, to buying and selling, or the interchange of commodities, and it did not comprehend navigation. He explained that Ogden's construction would, quote, restrict a general term, that is commerce, which is, quote, applicable to many objects, to one of its significations, meaning trade or traffic. Instead, Marshall provided a broader interpretation of the meaning of the word commerce. He explains that, quote, commerce undoubtedly is traffic, but it is something more. It is intercourse. It describes the commercial intercourse between nations and parts of nations in all its branches, and is regulated by prescribing rules for carrying on that intercourse. Study guide. Is intercourse broader than commerce? Next, Marshall explained that the phrase among in the Commerce Clause is defined as intermingled with. He explained that comprehensive as the word among is, it may very properly be restricted to that commerce which concerns more states than one. The word concerns is another broadening term. When the words of the Commerce Clause in the Constitution are replaced by the synonyms used by Chief Justice Marshall, the power seems to be broader, or so later courts would rule. What, if anything, is outside the power of Congress to reach? Marshall then places an important limiting principle on the scope of Congress's powers. Because the Constitution enumerates 3 specific powers to regulate commerce with foreign nations, among the several states, and with Indian tribes, then, quote, that enumeration presupposes something not enumerated. Otherwise, the Constitution would simply have given Congress power over all commerce. Marshall says that the Constitution does not give Congress the power to regulate, quote, exclusively internal commerce of a state. Such exclusively internal commerce, he added, may be considered as reserved for the state itself. Marshall's conclusion is supported by the text of the 10th Amendment, which provides, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. If an enumerated power is not delegated to Congress, then it is reserved to the states, or the people. Study guide. Is commerce taking place entirely within a state always outside Congress's powers? Or could Congress sometimes reach that local commerce pursuant to its necessary and proper clause authority? With this broad reading of commerce and among, the court found that Congress had the power to enact the federal law that licensed the boats. As a result, the state law, which limited boats from entering New York waters, was preempted and was unconstitutional. This conclusion is also supported by compelling evidence that the original meaning of commerce included navigation. As in McCulloch versus Maryland, Marshall can be accused of casually employing expansive and comparatively imprecise rhetoric that was later relied upon to undercut the enumerated power scheme he is actually reaffirming.